The man you see being wheeled into court is facing incredibly heinous charges. This video per WTOL. A grand jury indicted this father on 15 counts, including murder, rape, kidnapping, and gross abuse of a corpse. All are related to the death of his own 13-year-old daughter. Her body was allegedly left in a vacant home. But that story is not the only problems that Darnell Jones allegedly caused in Ohio.
Where am I? What's your name? Kill me.
Jones is also seen on this body cam video, allegedly pulling a gun on police in another city while he was allegedly on the run. We're on the case presented by Law&Crime. I'm Chris Stewart. We have an update on a case that is hard to comprehend and new video of the man that police say is responsible. This is Darnell Jones. He also goes by Darnell Ogletree. This is him being wheeled into court this week in Toledo, Ohio. This video is per WTOL. Now, there are multiple layers to the issues that Jones is now facing, but at the core of this story is the loss of life of a girl who was an honor roll student. She loved playing basketball with her friends, and according to local media, she was set to receive a kindness award before she was killed. Her name was Kei'mani Latigue. She was just 13 years old. Police say she went missing on March 18th, and less than a week later, her body was found in a vacant house. It's a house that used to stand here. There's now memorials surrounding the lot. We'll get into what happened to the home in just a moment. This in Toledo, Ohio. When Kei'mani's body was found, there was a warrant out for her dad's arrest. On March 25th, police in Columbus found Jones walking on the street, and this is what happened next.
Where am I? What's your name? Kill me. Dude, show me your hands right now. Pull your hand out. I swear to God, pull your...
At that moment, you can see Jones make a sudden movement, and the officer fires multiple times. I can't show you the moment that officer's fired because of the rules here on YouTube. You also might have heard what sounds like Jones saying, quote, "Just kill me," as the officer pulls his weapon to confront him on the street. So let's pick up the video here as officers now search Jones, who is on the ground and wounded, but still alive.
Shots fired! Shots fired! There's in a second! Yeah, medic, go!
Don't move!
Don't move! Alright, suspect down. All you guys are okay.
Don't move. He's got 33 right there.
33 in his hand!
No, it's a walkie-talkie, but there are 33s right here. Don't you move or you're going to get shot, okay? All right? Got it. Yep. That's him. Somebody get
on the main air. Get us a medic. I'm working on it.
If you look closely at the video, you can see the gun that Jones allegedly pulled on officers. Jones was in the hospital until April 10th when he appeared in court in Columbus. He was held without bond. At that time, he faced a charge of felonious assault on a police officer in Columbus. The court ruled that he would be extradited to Toledo to face the more serious charges of what he allegedly did to his daughter. And that brings us to where we are now in this case. A grand jury returned this 15-count indictment against Jones. We know, according to the coroner in Lucas County, that's where Toledo is, that Kei'mani Latigue's cause of death was related to multiple incision wounds to the neck. That means that something was sharp, like a knife, and that was used to kill her. But the new grand jury indictment lists graphic and disturbing details about what Jones allegedly did, including not only allegedly murder, but rape. The indictment specifically says that Jones allegedly committed the offense with a sexual motivation, and it lists him as a sexually violent predator. The grand jury also says that Jones allegedly tortured or cruelly abused his daughter, and that Jones allegedly treated a human corpse in a way that would, quote, outrage reasonable community sensibilities. I want to take a moment to talk about one of the sponsors of On the Case, Thrive Market. If you're like me, you care about what you put into your body, but finding those high-quality groceries at an affordable price can be really difficult, and that is where Thrive Market comes in. When it comes to shopping for food online, Thrive Market, it's really become my go-to grocery store where I can shop healthy and sustainable products, and they're all delivered right to my door. And one of the best parts is that Thrive Market does the heavy lifting by restricting over 1,000 questionable ingredients from all the products that they carry. I love these coconut oil sweet potato chips. We work long days here at Law&Crime. They're great to have to kind of fight back those cravings in a healthy way throughout the day. With Thrive Market, you can shop everything from pantry staples and snacks to personal care items, all from the comfort of your own home. Plus, their commitment to sustainability means you are not only taking care of yourself, but you're taking care of the planet as well. And with their easy-to-use website and app, you can filter by dietary preferences, whether you're keto, gluten-free, vegan, or just trying to make healthier swaps. Thrive Market has something for everyone. So if you're ready to make healthy food shopping as easy as just a couple of clicks and have the food show up right at your door, give Thrive Market a try. You can scan this QR code on your screen. You can also use the link in the description box of this video, or head over to thrivemarket.com/onthecase, and that will give you 30% off your first order and a free gift. Jones is facing 4 counts of aggravated murder, 2 counts of rape, 3 counts of kidnapping, aggravated burglary, 2 counts of endangering children, 2 counts of tampering with evidence, and 1 count of gross abuse of a corpse. Here's what else we've learned when it comes to the investigation into Jones. We've pulled court documents that show he is charged with murder and assault, and in the document originally filed related to an abduction charge, the court records allege that Jones did remove his daughter without the consent of her guardian, reportedly her grandmother, from her home. The document also says that when police spoke with Jones, he gave inconsistent statements about where he went with his daughter. And this is not Jones' first interaction with the legal system. We were able to pull records that go back to 2011 when Jones was arrested for arson for allegedly lighting a commercial building on fire. Then in 2015, he was arrested for carrying a gun after being convicted of the 2011 felony arson, and a witness said he had fired a gun outside a house in Toledo. Then in 2017, we found that he was arrested for felony assault, where police say Jones smashed an alternator into a man's face and sent him to the hospital, where he had to receive 20 stitches. Then in 2022, he was arrested again for carrying a weapon while having been a convicted felon. And the most disturbing charges, though, those are the ones that he's accused of in the case where he allegedly murdered his daughter. I want to show you this video that we just shot of where the vacant home once stood, where Kei'mani Latigue's body was found in Toledo. Again, this was a vacant building. If you look at this image on Google Maps, you can see what this house looked like. But this past weekend, the home burned down. The home has become a place where people have come to place flowers to honor Kei'mani Latigue's life, a life that was cut so short. Again, just 13 years old. Latigue was in the care of her grandmother. Jones did not have custody. This family was known to the local family services organization. In the wake of Latigue's death, a task force was formed to investigate Lucas County Children's Services and how they handled the case. The head of the organization told WTVG-TV that they feel they were thorough in her case. They say that Kei'mani was in the custody of her grandmother, who admitted to using physical discipline, but there was no evidence that meant that Kei'mani should be taken from the home. They also say the teen said she felt safe in the home. WTOL reports that the agency says there is no mention of Darnell Jones in their records. Joining us now is prosecutor and former Deputy Attorney General for the state of Ohio, Mark Weaver. Thank you, sir, for taking the time to be with us on what is such a difficult story. We have this 15-count indictment returned by a grand jury. What should we take away from what the grand jury put forward in this case against Darnell Jones?
This is Lucas County, Ohio, where Toledo is. We don't see a lot of death penalty cases coming out of Lucas County. This will be a death penalty case unless it gets reduced in some sort of plea agreement. So this will move forward as a death penalty case. I've worked on numerous of them, both death penalty cases, both as Deputy Attorney General and then as a prosecutor. Much more difficult case to bring. Every bit of due process you can imagine is built into it. All of the work of the prosecutor has to be exacting and painstaking to make sure everything is done correctly. So I imagine that the Lucas County prosecutor will put their very best people on this.
And when you look at a 15-count indictment, and it's horrific what this man is accused of doing to his own daughter, what is the difference between a grand jury putting forth an indictment and then where the process goes from here, where eventually, if Darnell Jones is convicted, the difference between that grand jury phase and then the trial jury phase?
Under the Ohio Constitution, every felony charge must be brought forward by a grand jury. As your viewers know, that's a group of citizens who meet in secret and look at the evidence to see if there's probable cause that a felony was committed. So the grand jury handed up this 15-count indictment with all of these felonies, any one of which could serve 10 or 15 or 20 years. Some of these will merge, meaning that he can't be sentenced on all 15 of them, but he can be convicted on all 15 of them. And it now moves to the trial process. So there will be pretrial motions. Almost certainly the defense is going to raise some sort of competency issue. There's very little daylight for them to be able to move around in this case. So I would imagine we're going to see some form of incompetency issue. Maybe they have some quarrel with how he was arrested or if there was a search warrant. So there's likely to be a motion to suppress. So these pre-trial motions that happen in the months ahead of a criminal trial, that's the phase we're moving into next.
You look at this case, and the family was known to the local Child and Family Services organization in Lucas County, but there was no evidence, from what we've heard so far, that there was no evidence to remove this child from the house from previous instances. She had been in the care of her grandmother. In your experience, what do you take away from what we're reading about some of the potential red flags leading up to the death of Kei'mani Latigue?
Well, there's the criminal case, and it appears this man, Darnell, two different names, last names, I'm not sure which is the right one, but it seems like Darnell is squarely at fault and culpable for this case. He's presumed innocent until he's proven otherwise, of course. But then there's a civil case, potentially, to see whether or not the county committed any negligence in supervising this child. I've worked with a lot of children's services agencies over the years, and here's the thing that most people don't know. They are overwhelmed with cases. They are overwhelmed with allegations and referrals, and they are not mind readers. So when they go out to a home to do a check on a child, they can't know that perhaps there's a father out there with deeply evil intentions who's going to show up one day and do the sort of crimes that this man has been charged with. And so it's a high standard to sue the county to say that they're somehow responsible, but we see it often in cases like this.
And you look, and I just think of your time as a deputy attorney general, and you see some of the challenges in the state of Ohio, and we've heard stories of child and family services organizations, how overwhelmed they are, and sometimes it seems we only hear about them in cases where people are like, why didn't you do more in that situation? But in these cases, I mean, typically, what is the bar? And I know your experience is more from the prosecutor's side, but what is the bar to remove a child from a home?
Well, and ironically, in Ohio, the prosecutor's office is the statutory counsel for the Children's Services Agency. So when they get sued, the prosecutor defends. It's not true in every case, but it is in Ohio. That's how it works. You have to be able to show that the people who were supposed to be monitoring this child, the people who work at the Children's Services Agency, had some reason to know that this was possible or even likely, and that they ignored that. It's a pretty high standard. It can't just be that they weren't careful and didn't check every box. It has to be something that would suggest that they were well outside what we expect from our children's service workers. And if that's true, then the county can be sued for money damages, and that case would be brought by the family of the dead child.
Going back to talking about the death penalty and the possibility of that being the fate of Darnell Jones, if he is indeed found guilty of what police are alleging, what does the process look like where someone commits murder? It's awful. But if they were to commit murder at the level of what we're reading in this grand jury indictment and what police are saying he did, how does it get to that bar where the state decides that this is a case where life in prison is not good enough if someone's found guilty?
So in most states, certainly in Ohio, we have murder charges, and then we have aggravated murder charges. So murder is your actions killed somebody, and aggravated murder is your actions killed somebody, and you acted with prior calculation design, and maybe it was a certain kind of somebody. Maybe it was a police officer, maybe it was a child under 13, or in this case, maybe you were committing another felony in addition to the murder, and that makes you death penalty eligible. These are aggravating circumstances to murder, which is why we call this form of murder aggravated murder, or also known as capital murder. Now, let's be clear. I will not be surprised, nor should your viewers be surprised, if there is a plea agreement that goes something like this. Prosecutor to defense counsel: If your guy will plead to ag murder without the death spec and accept life in prison, we will drop the death penalty charges. We'll go, and this will be done in a few months. I suspect that sort of conversation will happen. Who knows? The defendant has to agree to that. Maybe he thinks he can roll the dice and get past this. But if he would like to avoid being executed, that's one way to do it.
Why would the prosecutors, if they have, and it appears they have a lot of evidence, apparently he also admitted to police officers that he did this. That was according to WTOL and documents that they looked through. So it seems like if you're prosecutors, why would you want to make a deal if you already have a mountain of evidence and you feel pretty good about how strong your case is?
As a prosecutor, I always want to move forward and try cases. I do this on a part-time basis. In Ohio, you can be a part-time assistant prosecutor. So this is where I get my jury trial experience. So I enjoy prosecuting cases, but sometimes it's better to resolve it this way. Here's why. Number one, we've not had an execution in Ohio for more than 8 years. There's been a dispute over the form of execution, which is lethal injection, and the kind of chemicals available to make that lethal injection happen. So Ohio is not currently executing people. Number two, there is so much scrutiny on death penalty cases in the appellate process. It can go on for years and years and years. And the loved ones of the person who was murdered don't get the closure they would if there's a sentence that says, yep, you're going to prison for the rest of your life. You pled to it, so your appellate rights are very limited. If it's resolved that way, the victim's family will leave the courthouse knowing almost certainly that this life in prison sentence will stick. In a capital case, and I remember meeting with the families of the victims of a serial killer who I prosecuted in a death penalty case. I met with them right after the conviction and the sentence. And they asked me, is it sure? Are we sure that this is going to happen? And as I always say, you can never be sure. In a death penalty cases, there are so many appellate rights and so much scrutiny brought on it. Any court, state or federal, can overturn that verdict and send it back down for another trial.
What does the timeline look like on this case? And how do we get to the point where the judge or jury would say that the death penalty is what we're going with for a sentence for Darnell Jones if he's found guilty?
So from the date of the indictment, a defendant has to be brought to trial within 270 days in order to guarantee his speedy trial rights. If the defendant is in jail awaiting trial, every 1 day counts as 3. So it's essentially 90 days to bring it. What almost always happens, I haven't seen this in this file yet, but what almost always happens, the defense waives that speedy trial right, so they have time to look at the evidence. Or if they file motions, it tolls or pauses the speedy trial clock. So in theory, it's supposed to happen in 90 days. Almost never does it happen in 90 days because of those pausing events that I just told you about, either voluntarily pausing or filing a motion that causes them to pause. During this time, the defense counsel will be looking at all the evidence that the prosecutors and police have amassed, looking for some hole in the case. As I mentioned, probably filing a competency motion or filing a motion to suppress, trying to find some way to get their guy out of what appears to be a pretty strong case.
Yeah, and I think too that it's not the only case that he's facing, because when he was arrested, he allegedly pulled a gun on police and police had to shoot him. We have the body cam video of that. So he's facing felonious assault on a police officer in Franklin County, Ohio. How does it work where he has a lot of layers to his legal case in Lucas County, but then you also have a very serious case in Ohio as well, in Columbus, Ohio?
Yeah, Franklin County was where Columbus is. That case has been dismissed for now. It can be brought again. They dismissed it in Franklin County to allow for the extradition of this defendant back to Lucas County, where his real problems are. I wish I could tell you that people who commit felonious assault on police officers in Franklin County go to prison for long periods of time, but they typically don't. And so I'm sure that the Lucas County prosecutors were happy to have the case essentially dismissed in Franklin. It could be brought again, but his real problem is in Lucas County. I wouldn't expect that you'll see anything in Franklin County unless something goes sideways in Lucas. If for some reason there was a procedural defect and that case gets dismissed, then you would see Franklin County, hopefully, depending on that prosecutor's ethos, bringing a strong case for that felonious assault charge against the police officers in Columbus.
Yeah, because how long does you would think someone who would pull a gun on a police officer and in that situation that would be enough for someone to see prison time, but that typically doesn't happen there.
Well, there's a lot of it. First of all, there's a 6-year statute of limitations, so that case can be brought anytime in the next 6 years. But depending on the judge you get, and judges are elected in Ohio, and different judges have different perspectives. Some of them come from a defense lawyer background, and they're much less likely to give out a serious sentence. And so as a result, the best chance for this defendant to be in prison for the longest time is going to be this case in Lucas County, which will either be pushed to a death penalty trial, which is a significant, difficult undertaking, or as I suggested, will be pled down to a straight aggravated murder without the capital spec, meaning life in prison without any possibility of the death penalty.
I'm always fascinated for the people who try cases and the responsibility, and you know it as well as anybody, the responsibility you carry, even in a case where it seems like you have every piece of evidence in the world to convict this person who's incredibly dangerous based off his criminal record in the past and what he's accused of right now. What is it like to be in the prosecutor's office and being the person who is going to be trying this case if it gets to that point?
It's an exhausting process. As the prosecutor, you have the complete burden of proof. The defense counsel doesn't even have to prepare and show up with a case. They do, but they have no burden of proof. And so when we all sit down at trial and the jury takes their seats in the jury box and the judge looks over to the prosecutor and says, "Mr. Weaver, on behalf of the state of Ohio, you may begin." All of the burden is on us. Have we identified every possible witness and given it to the defense? Have we talked to each witness so we know what they're going to say? Do we have our questions ready? Have we marked every piece of evidence? Was it gotten properly? Was it shown to the defense counsel? Then we have the questioning process. The other side gets to cross-examine, and we come back and we get direct examination. Then we have the opening and closing statements, and we have maybe a rebuttal case, which comes after the defense case. At any point, if the defense counsel says something was done wrong and asks for a mistrial, the entire thing can stop and has to start over again. Or in significant cases, sometimes can't even start again. So the prosecutor's got a tremendous burden on them. I will be in trial next week, for example, on a child rape case that I'm on the prosecution team for. And so I know this weekend I'll be spending a lot of time looking at that evidence, preparing my portion of the case, and getting ready for what is a very important case.
And you look at this story, and in hindsight, you look at Darnell Jones, and he had a record that included arson, carrying a gun when he wasn't supposed to. There was an assault case that he had in the past. Nothing related to sexual misconduct from what I was able to see, sexual assault, or something as serious as murder, as he's accused of in this case against his own daughter. He did not have custody of this girl. It seemed like Child and Family Services was at least aware of the family. I just look at this, and it's what more could have been done. And just in your experience, what more could have been, what needs to change in the system so you don't have a situation like this? Or is someone like Darnell Jones, who just seems, from what he's accused of over and over and over again, committing crimes, just someone I don't know if inevitable is the word, but it just seems that what more could have been done to stop him from what he's accused of doing?
I spent most of my career working in and around law enforcement, local law enforcement, county level, state. I was a spokesman at the Justice Department in Washington, D.C. early in my career. And so one thing I've seen looking at all these cases is that there is evil in this world, and there are people who are willing to commit that evil. There is nothing we can do to make that go away completely. We want to do the best we can with the tools we have, but we live in a free society. And so the ethos of the founding of America is that people get to be free of government intrusion and government surveillance to the greatest extent possible. So we don't know what lives in the hearts of people who are thinking about what they're going to do to somebody. What we want to do is, once somebody is identified as a violent person in another case, we need to give them longer sentences, because one thing we do know, that if they're behind bars, they can't prey on innocent people in the community. Longer sentences helps, stronger sentencing laws helps, and having a serious approach to law enforcement and supporting our police. These things are all important ways to keep us all safe.
All right, Mark Weaver, former Deputy Attorney General of the state of Ohio and prosecutor. We appreciate you coming on. I mean, this is such a sad story, a tragic story, and your perspective really helps us break it down. Thanks for being here.
Let's all pray for this family. I know I am. Thank you.